My name is Lauren Mercer. I'm 38 years old. And while I was lying in a hospital bed fighting a severe autoimmune relapse, my mother transferred the $8.2 million company I built from the ground up into my sister's name. I did not find out from my family. I found out when my corporate login stopped working. The relapse happened fast. I had been managing symptoms for years, but this episode escalated within days. My doctors admitted me after my inflammation markers spiked and my organs began showing stress signals. I was exhausted, heavily medicated, and confined to a monitored unit for nearly 3 weeks. But I was conscious. I answered emails. I approved vendor payments. I participated in 2 executive calls by video from my hospital room. The company did not pause because I was ill. When I was discharged, I expected to return to a backlog of decisions and a sympathetic team. Instead, I received an automated notice from the state corporate registry informing me that an ownership amendment had been filed. Majority shares transferred. New controlling shareholder, Amelia Mercer. My younger sister. I assumed it was an administrative error. It wasn't. When I tried to access the company's primary banking portal, my credentials were restricted to non-authorized viewer. My executive authority was downgraded. I called our general counsel immediately. There was hesitation before he answered my questions. Your mother submitted an emergency proxy authorization, he said carefully. It activated the temporary incapacitation clause in the operating agreement. I was not incapacitated, I replied. The documentation stated you were medically unable to perform executive duties. I attended board calls from my hospital bed, I said. There are recordings. He paused. The board voted to authorize interim control under the clause. He continued. Your sister was appointed majority managing shareholder. That was when I realized this was not clerical. It was strategic. 8 years earlier, when I formed Mercer Biotech Solutions, I retained 72% of voting shares. The remainder was distributed among early investors and option pools. My mother and sister held no ownership stake beyond minor advisory equity units with no voting control. The company grew aggressively. We secured federal contracts. We closed 2 acquisition rounds. The last independent valuation placed us at $8.2 million in enterprise value. My mother began appearing at events once the numbers became public. My sister joined the marketing department 2 years ago in a salaried role. But neither of them owned it. Now, according to the filing, Amelia held controlling interest. Send me the proxy authorization, I told counsel. He emailed it within minutes. The document stated that due to medical incapacitation preventing executive function, temporary control was transferred under emergency governance protection. It included a digital signature bearing my name. I stared at it for a long time. The signature was not mine. The timestamp was from the 3rd night of my hospitalization. That evening, I had been on a monitored IV drip but alert enough to sign off on a supplier contract. I still had those emails in my inbox. The emergency clause in our operating agreement allowed temporary reassignment of authority only if the managing member was legally incapacitated and unable to communicate. I had been communicating daily. The next document attached was a board resolution approving the transfer. My mother's name appeared as acting family representative under protective oversight. Protective, that word carried weight. They had framed the takeover as stability. They had positioned my sister as continuity. And they had used my illness as justification. I called my mother. She answered on the 2nd ring. You're out already? She asked casually. What did you file? I said. There was no confusion in her voice. You needed protection, she replied. The company couldn't be leaderless. I was leading from the hospital. You were vulnerable, she said. We had to act. By forging my authorization. Silence. It wasn't forgery, she said finally. It was necessity. 3 months later, a judge would use a different word. But that afternoon, sitting at my kitchen table with discharged papers still in my bag, I understood one thing clearly. They hadn't just moved paperwork. They had attempted to erase ownership. And ownership unlike sympathy, is documented. Mercer Biotech Solutions did not begin with family support. It began in a rented lab space with 2 used centrifuges and a line of credit I secured personally at 30% interest because no one believed my model would scale. 8 years earlier, when I pitched the idea of developing rapid pathogen detection software for mid-sized medical facilities, my mother told me it sounded ambitious but unstable. My sister Amelia said biotech was saturated and suggested I consider consulting instead. I did not resent them for it. At the time, skepticism felt normal. I wrote the early code myself. I negotiated our first supplier contracts without leverage. I drove samples across state lines to secure beta partnerships because we could not afford a distribution team. When we landed our first federal pilot contract, the revenue barely covered operating costs. I reinvested everything. I paid myself last. By year 3, we had 12 employees. By year 5, we closed a $2.4 million expansion round. By year 7, our valuation crossed $8 million. That was when my mother's involvement changed. She began introducing herself at events as Lauren's strategic advisor. She asked to sit in on investor calls, just to observe. She told me she wanted to understand the business better in case something ever happened to me. I did not think twice about it. Family presence did not equal control. Our operating agreement was explicit. Voting shares remained mine unless voluntarily transferred. Emergency clauses required medical certification of incapacitation and independent verification before activation. Amelia joined the company 2 years ago as director of marketing. She was competent, though inexperienced in biotech. I created her role carefully, defined performance metrics clearly, and kept her compensation consistent with industry standards. She held stock options contingent on tenure, not ownership control. The day I was admitted to the hospital, I emailed the executive team outlining temporary delegation of daily approvals to our COO. It was procedural. We had contingency planning for short-term health interruptions. The company had weathered supply chain disruptions and regulatory audits. It would survive 3 weeks of my reduced mobility. What I did not anticipate was my mother contacting general counsel privately. Later, through discovery, I learned the sequence. On my 4th day in the hospital, she requested a meeting with counsel citing urgent continuity concerns. She presented a physician's note confirming hospitalization, but not incapacity. She argued that investor confidence required formal activation of the emergency clause. The clause was designed for coma scenarios or legally certified inability to communicate. I had been emailing hourly. She claimed I was under heavy sedation and unable to execute fiduciary duties responsibly. Amelia attended that meeting. Within 48 hours, the board convened without me. The resolution described the action as temporary, but authorized majority share reassignment for operational stability. The digital authorization bearing my name was submitted as evidence of consent. It was not my signature. When I reviewed internal email logs after my discharge, I found something else. Amelia had accessed my corporate document drive twice during my hospitalization. My signature files were stored there for vendor contracts. She had administrator-level access to marketing assets, not legal archives. That access required escalation, which meant someone authorized it. I called our COO. "Did you vote for this?" I asked. "I was told you approved it," he said quietly. "Your mother presented documentation." I forwarded him the email thread from the same timestamp showing me approving budget reallocations. There was a long silence on the line. "I thought it was temporary," he said. "So did they," I replied. "Until it wasn't." The most dangerous element of the takeover was not aggression. It was presentation. They did not storm the office. They filed paperwork. They did not announce removal. They activated a clause. They framed it as protection. But protection requires consent, and I had given none. By the time I fully reconstructed the timeline, one fact became unavoidable. This was not panic-driven governance. It was calculated, and calculated fraud leaves trails. Once I had access to the internal logs, the story stopped being emotional and started becoming chronological. On the third day of my hospitalization, my mother emailed our general counsel requesting a continuity discussion. She attached a brief hospital confirmation letter stating I had been admitted for autoimmune complications and would remain under observation. The letter did not mention cognitive impairment. It did not state incapacity. It did not recommend legal guardianship or executive suspension. It simply confirmed admission. The following morning, she requested administrator access to my executive document folder to assist with urgent contract review. That access was granted temporarily by IT after counsel approved it. 46 minutes after gaining access, a new file appeared in the folder labeled Emergency Proxy Authorization, Managing Member. The metadata showed it had been created on my home office laptop, not from the hospital network. I had not been home in 5 days. The document stated that due to medical incapacity and inability to discharge fiduciary duties, I voluntarily authorized temporary transfer of voting control to an appointed family representative. That representative was listed as Amelia Mercer. The signature field contained my digitized signature image. The timestamp placed it at 11:38 p.m. At 11:42 p.m., my hospital email records show I sent a supplier confirmation regarding a reagent shipment delay. The tone was direct. The instructions were precise. There was nothing impaired about it. The next day, the board received the proxy document along with a memo from my mother stating that Lauren's condition had deteriorated unexpectedly and decisive action was required. She described me as unstable, medicated, and unable to responsibly manage risk. There were no medical affidavits supporting that claim. The emergency clause in our operating agreement required independent medical certification of incapacity and majority board confirmation. The certification never existed. Instead, my mother relied on urgency. Investors were told that activating the clause would reassure partners and avoid disruption. My sister was presented as a stabilizing internal executive who already understood branding and operations. The vote passed by narrow margin. 2 independent directors abstained, citing incomplete documentation. But abstentions did not block the resolution under quorum rules. Within 72 hours, an amendment to the state registry was filed, transferring controlling shares to Amelia under emergency governance provision. Temporary became effective immediately. Temporary had no defined end date. When I reviewed Amelia's internal correspondence during that week, I found emails drafted before my hospitalization that referenced eventual majority structure. She had asked counsel months earlier what would happen if I became unable to serve. That question, in isolation, was reasonable. The timing was not. On my 6th hospital day, she emailed a senior marketing manager. Once the transfer finalizes, we'll reposition the company narrative under my leadership. There was no uncertainty in that sentence. When I confronted my mother about the forged authorization, she did not deny involvement. "You were not thinking clearly," she said. "You would have signed if you understood the risk." "I did understand the risk," I replied. "That's why I never signed." She framed it as protection. "You built something fragile," she said. "We made it secure." Fragile. The company had survived market volatility, regulatory scrutiny, and 2 funding negotiations. It had not survived internal ambition. The final element that shifted this from questionable governance to actionable fraud was technical. The digital signature embedded in the proxy file matched a PNG image stored in my archived contracts folder. Not a live signature, not an authenticated digital certificate, a copied image. That distinction would matter in court. By the time I completed the forensic review, there was no ambiguity left. They had not misinterpreted the clause. They had constructed justification around access they should never have used. And once access is abused, intent becomes visible. I did not argue further at the kitchen table. I hired litigation counsel. I retained an independent litigation firm within 48 hours of confirming the forged authorization. Not a corporate attorney who had been involved in the internal vote. Not anyone with prior ties to my family. I needed distance. The first thing my attorney asked for was a clean timeline, not emotional context, not family history, just documents. We assembled everything: hospital admission records, email logs, metadata reports, board minutes, registry filings, server access timestamps, and the original operating agreement. When he finished reviewing the file, he looked up and said, "This is not a governance dispute. This is fraudulent inducement and unauthorized transfer." We filed suit within 2 weeks. The complaint alleged fraudulent execution of proxy authorization, forgery of digital signature, breach of fiduciary duty by board members who approved without proper certification, unlawful transfer of controlling shares, civil conspiracy to misappropriate ownership. The court granted an expedited hearing due to active ownership control dispute over an operating business. My mother and sister retained their own counsel. Their defense was structured around one argument: incapacity. They claim that I was under heavy sedation, cognitively impaired, and unable to act in the company's best interest. They argued the emergency clause was triggered out of necessity. They characterized the proxy as authorized in substance, if not in technical execution. In other words, they admitted the process was imperfect, but claimed the intent was protective. Intent does not replace documentation. During discovery, we subpoenaed hospital medication logs. The records showed I had been administered anti-inflammatory therapy and monitored steroids. No sedatives impairing executive function were prescribed during the timestamp window of the proxy creation. We introduced the email thread sent 4 minutes after the alleged signature time. It contained specific supplier adjustments, pricing confirmations, and operational directives. My tone was clinical and precise. We also introduced server metadata proving the proxy file was created from my home IP address while I was admitted to the hospital 30 miles away. Amelia's access logs showed she entered my document archive 46 minutes before the proxy file appeared. Her attorney attempted to argue administrative necessity. The judge asked one question that shifted the tone of the courtroom. Was there a certified medical declaration of incapacity at the time of transfer? The answer was no. The emergency clause required medical certification and inability to communicate. I had been communicating hourly. Next, my attorney presented a forensic analysis of the digital signature embedded in the proxy. It was a static image copy from a contract executed 18 months earlier. It lacked digital certificate authentication. It was not generated through our secure signing platform. That detail dismantled their claim of implied consent. My mother took the stand. She testified that she believed I would have approved the transfer had I been fully aware. Belief is not authorization. Amelia testified that she acted to preserve investor confidence. Investor confidence had not been threatened until ownership changed. The final blow came from one of the independent directors who had abstained from the vote. Under oath, he stated he expressed concern about insufficient documentation, but was told by my mother that delay could result in financial instability. There had been no instability. The valuation remained stable throughout my hospitalization. The hearing lasted 6 hours. By the end, the issue was no longer emotional. It was technical, and technical fraud leaves evidence. 3 months after the proxy filing, the judge issued a written ruling. The first sentence stated, "The transfer of controlling shares was executed without valid authorization and is therefore void ab initio," void from the beginning, which meant, legally, it had never happened. And every action taken under that false control would now be examined. The ruling was 22 pages long. It did not reference family betrayal. It did not comment on emotion. It analyzed procedure. The court found that the emergency incapacitation clause had been improperly invoked. No certified medical declaration of incapacity existed at the time of the transfer. No independent verification confirmed inability to communicate. The operating agreement required both. Neither requirement was satisfied. The proxy authorization containing my digitized signature was declared fraudulent. The forensic analysis established that the signature image had been copied from a prior contract file and inserted without authenticated digital execution. The court noted that intent to protect the company did not override contractual safeguards designed to prevent unauthorized control shifts. The order was explicit. The share transfer to Amelia Mercer was void ab initio. All controlling shares reverted immediately to Lauren Mercer. All corporate registry amendments filed under the emergency clause were to be rescinded within 5 business days. Legal costs associated with the improper transfer were assessed against the defendants. Additionally, the court issued a formal reprimand regarding misuse of fiduciary authority. While it stopped short of criminal referral, because we had pursued civil remedy, the language was direct. Emergency governance mechanisms cannot be weaponized to circumvent ownership rights under the guise of stability. Weaponized? That word carried weight. Within 48 hours of the ruling, the state registry updated control records. My name reappeared as majority managing shareholder. Banking credentials were restored. Executive authority reverted automatically under the operating agreement. The board convened immediately. 2 members resigned. The general counsel submitted his resignation pending internal review, acknowledging procedural failure in verifying certification requirements. Amelia remained silent throughout the emergency meeting. My mother attempted to speak about reconciliation. I redirected the conversation to governance. The board voted to suspend Amelia from executive authority pending internal audit review. Her stock options were frozen, subject to contractual violation clause assessment. The company issued a brief public statement. Ownership dispute resolved in favor of original founder pursuant to court order. Operations continue without disruption. No reference to family. No elaboration. Investors responded predictably. Stability restored confidence faster than explanations ever could. That evening, I returned home with the certified copy of the ruling in my bag. $8.2 million in enterprise value had nearly shifted hands because a clause was exploited. Illness had been framed as vulnerability. But ownership is not determined by who appears strongest in a moment of weakness. It is determined by documentation. 3 months earlier, they believed a hospital stay made me defenseless. The court disagreed. And the court's order did not just restore shares. It restored structure. Fraud leaves fingerprints. And once identified, it reverses itself under scrutiny. Control returning on paper was immediate. Trust returning was not. In the weeks after the court order, I did not celebrate. I audited. Every contract signed during the disputed 3-month period was reviewed. Every vendor agreement approved under Amelia's authority was examined. Fortunately, no irreversible structural changes had been executed. The company had been repositioned publicly, but operational foundations remained intact. I convened a full governance review. The emergency incapacitation clause was rewritten. Future activation would now require independent medical certification from 2 licensed physicians, direct video confirmation if the managing member was conscious, supermajority board approval including at least 1 external director, court notification within 72 hours. Ambiguity would no longer exist. Amelia resigned from her executive role before the board could formally terminate her. Under her employment agreement, misconduct voided accelerated equity vesting. Her unvested options were canceled. She did not argue. There are moments when legal defeat removes negotiation leverage entirely. My mother attempted to speak with me privately several times. At first, I declined. Eventually, I agreed to meet her in my office during business hours. She looked smaller there. I was afraid, she said. Of what? I asked. That if something happened to you, everything would collapse. It didn't collapse, I replied. You tried to take it. I thought you were too sick to fight. The honesty was clinical. You underestimated documentation, I said. She nodded slowly. I didn't think you would sue. You didn't think I would survive. Silence filled the room. I was protecting the family, she said finally. You were redistributing ownership, I answered. There was nothing left to debate. I did not pursue additional damages beyond the court-ordered costs. Civil remedy was enough. Criminal escalation would have fractured the company further. But access changed. My mother was removed from advisory visibility entirely. She no longer attended investor events. She no longer had internal access to documentation. Family and governance were separated permanently. 6 months later, Mercer Biotech Solutions secured a new federal contract larger than any prior year. Revenue projections increased. Stability strengthened valuation beyond the previous $8.2 million estimate. Illness had not ended the company. Fraud had almost disrupted it. The experience altered something deeper than corporate structure. I had once believed family proximity meant loyalty. Now I understood that proximity without boundaries invites assumption. And assumption, when combined with access, becomes risk. On the anniversary of the ruling, I reviewed the original proxy file again. The copied signature still looked like mine at first glance, but it was flat, static, detached from context. Ownership is not an image. It is an executed instrument backed by verification. They believed illness made me weak. They believed urgency justified shortcuts. They believed paperwork could rewrite authorship. What they forgot was simple. Every share has a trail, and trails lead back to the truth.